Para for dictation, exercise number 10, 5 seconds to start. 5, 4, 3, 2, 1. In this case, admittedly, the appellant has withdrawn the suit 2 weeks after the suit had been filed. Full point. In other words, the appellant elected to pursue its remedies only under Article 226. Full point. The pleadings were also complete before the High Court. No doubt, the interim order which was passed by the High Court was obtained when the suit was pending. But by the time the writ petition was heard, the suit had already been withdrawn a year earlier. Although the appellant could not, on the High Court's reasoning, take advantage of the interim order, it was not correct in rejecting the writ petition itself when the suit had admittedly been withdrawn, especially when the matter was ripe for hearing and all the facts necessary for determining the writ petition on merits were before the court, and when the court was not of the view that the writ petition was otherwise not maintainable. Full point. In the instant case, petitioner had already filed proceedings before the Labour Court in the year 1989, and having failed to obtain interim orders from the court, petitioners had approached this court without disclosing the fact of pendency of proceedings before the court. Another distinguishing feature is that the fact which has been withheld could not be considered as material fact. The apex court in the reported judgment found that withholding of fact of institution of a suit could not have any bearing on the consideration of issue on the merits of the matter. However, in the instant case, had the petitioners disclosed the fact regarding availment of alternate remedy provided under the statute, this court would not have entertained the petition. The fact which has been withheld is a material fact. Full point. The third distinguishing feature is that the High Court in the reported judgment has rejected appellant's plea in that matter only on the ground of separation of material fact. In view of the matter, we do not find any merit in the contentions raised by the petitioners in the petition. Full point. Even otherwise, the High Court has a supervisory jurisdiction under Article 227 of the Constitution of India. Applying the principles thereof, the question of conferring the authority of appeal on a subordinate tribunal would be contrary to this constitutional scheme. Full point. The enforcement of Section 303 with effect from 15/12/2016 would not repeal the right or abrogate the right of a person to file an appeal against the order of a learned single judge.